皆さんおはようございます。バラードです。今日のトピックは中間の戦略です。Hello and welcome back to part 2 of the series in avoiding final office actions. And in the first part, I discussed MPEP 706.07a, and basically we talked about paragraph 1 of that section. And there are a total of 5 paragraphs that I think are important. So in part 1 we talked about the first paragraph, which is the basic rule of when is an office action final, the rule that you use the most. And the other paragraphs 2 through 5 are kind of not rare cases, but some other different situations that are not as common as paragraph 1. So I'm going to go through paragraphs 2 through 5 in this video. But really quickly, I just want to review part 1. What did we learn in part 1? So in part 1, we learned from MPEP 706 that a second or later office action cannot be final if the examiner makes a new ground of rejection against any claim that is not caused by your amendment or an IDS that you filed with a fee that contains prior art that the examiner used. So that's part 1. And if you haven't seen part 1, I would highly suggest to go watch part 1 first before you can watch part 2, this video. And after this video, I will be uploading a part 3, which is discussing the definition of a new ground of rejection. What is that? And there are rules for that as well. Okay, so let's start from paragraph 2. So MPEP 706.07a, second paragraph. This is the text, most of the text of the second paragraph. So a second or any subsequent office action, a second action or any action after that one, should not be made final. Should not. Not cannot or must not. Should not. So this rule is a little different from paragraph 1. It's not proper to make an office action final in this situation, but it's possible. So just trying to keep that in mind, the difference between what should not, must not, or may not, those kind of words. So should not means it's not proper, but it could happen. You could get a final office action in these situations. So the action should not be made final if it includes a rejection on prior art not of record of any claim amended to include limitations which should reasonably have been expected to be claimed by the examiner. So if the examiner kind of knows you're going to do this amendment, they shouldn't just reject it, your amended claim, and make the next action final. That's not really proper. And an example is where an examiner suggests how an applicant can overcome a rejection. So the examiner says, why don't you make this amendment to the claim? You do the amendment, and then the examiner rejects your claim again and then makes the action final. So it's really not proper to do that, but it happens sometimes. Basically in practice, so what's the basic meaning of this paragraph? If you amend the claims to, for example, to add features suggested by the examiner should not, but they can, but they should not then reject those claims on a new grounds and then make the next action final. They shouldn't do that because they told you to amend the claims that way. It wouldn't be fair. Okay, so let's move on to paragraph 3. A second or any subsequent action, just like every other paragraph, the second action or an action after that, on the merits in any application or patent involved in re-examination proceedings, okay, may not be final, may not be made final. So paragraph 2 said should not be made final. This is may not be made final, so it's not permitted to be final. So may not be made final if it contains a new ground of rejection necessitated by the amendments to pre-AIA 35 USC 102 E. Now you may remember the 102E in the AIA 102E was changed so that basically the result is there is now more prior art the examiner can use to reject your claims under AIA 102E. So looking at kind of the practical meaning of this paragraph, the changes in AIA 35 USC 102E, they increase the amount of prior art. So for example, some patents and publications were not prior art under pre-AIA 102E, but they are prior art under AIA 102E. So paragraph 3 is basically about pre-AIA 102E and AIA 102E. Okay, so fourth paragraph. Fourth paragraph is a long paragraph, so I split it into two parts, and actually the topics are slightly different. But basically paragraph 4 is relating to removing prior art based on the common ownership or the research agreement rules. So when applying any 35 USC 102A2 or pre-AIA 35 USC 102E 103 references against the claims of an application, the examiner should anticipate that a statement of varying common ownership, that's the statement the applicant files, that they say, hey, I own that prior art also, so you can't use it against this application. So it may qualify the applicant for the exemption under 35 USC 102B2C, that's AIA, or a statement of common ownership at the time the invention was made may disqualify any patent or application in a rejection under 35 USC 103 that is based on 102E. If the statement to remove this prior art is filed and the claims are not amended, the examiner may not make the next action final if a new rejection is made. So if you remove this prior art, the examiner cites some different prior art, makes a new ground of rejection, the next action may not be final. And we're using the words may not, so it's not permitted to be final. So in practice, what does this mean as a practical matter? So for example, prior art can be removed under 102B2C or 103C if the applicant owns the prior art. If the applicant removes that prior art by you file the statement that it's commonly owned, the examiner may not make the next action final if the claims are rejected again, if the examiner makes another rejection. All right, so the next part of fourth paragraph is relating to joint research agreement provision. So there's the common ownership was the first part, and then this is the joint research agreement provision. And so if a reference is disqualified under the joint research agreement provision of 35 USC 102C or 35 USC 103C, and a new subsequent double patenting rejection based on the disqualified reference is applied, the next office action that has the new double patenting rejection may be final. It can be final, even if the claims are not amended. Even if the applicant did not amend the claims, provided that the examiner introduces no other ground of rejection that was not necessitated by either amendment or information disclosure statement. That's relating to paragraph 1. And then, so the final sentence, the office action is properly made final because the new double patenting rejection was necessitated by amendment of the application. Right, so this is not amendment of the claims necessarily, it's amendment of the application in this situation. So it's considered that the application is amended here, therefore the next action could be final. So as a practical matter, in practice, what does this mean? So prior art can be removed under 102C, 103C under these joint research provisions, and if the applicant is successful removing the prior art, and then the examiner makes a double patenting rejection using the same removed prior art, the examiner may make the next action final even if the claims are not amended. All right, so let's go to the final paragraph that we're going to discuss, paragraph 5 here. Paragraph 5 relates to 102, 35 USC 102 pre-AIA and AIA differences. So this states, where the only changes in a rejection are based on treating the application to be subject to current 35 USC 102, so AIA 35 USC 102, rather than the version that was in effect on March 15th, 2013, that's the pre-AIA version, or the reverse, so if it's AIA and then you go to pre-AIA. And any prior art relied upon in the next action, the subsequent action, was prior art under both versions of 35 USC 102. Then the action may be made final. So we discussed before about US 35 USC 102E, AIA and pre-AIA. In that situation, the next action cannot be final because you've got, in one situation, it's not prior art under pre-AIA 102E and it is prior art under AIA 102E. This is a little different. This is prior art that is cited that is prior art under both pre-AIA and AIA 102. So in that situation, if the application is converted to from pre-AIA to AIA, and then the examiner applies the different version of 102, if the prior art that is applied, if it was also prior art under the other version of 102, then the next action can be made final. It's not a new ground of rejection for those purposes. So the last sentence here, for example, if a first action relied upon a reference as being available under 35 USC 102E and a subsequent action relied only on the same reference under 35 USC 102A2, then the subsequent action may be made final, assuming that there's no new requirements or non-prior rejections that were made. So, as a practical matter, what does this say? What does this paragraph say? If the examiner rejects your claims under pre-AIA 35 USC 102, the examiner may also reject your claims under AIA 35 USC 102 and make the next action final if the prior art used was prior art under both pre-AIA and AIA 35 USC 102. Okay, so that's it for MPEP 706.07A. And I'm just going to go over quickly again the consequences of a final office action. What happens when you get a final office action? Okay, so it closes prosecution and makes your options limited as to the response or what you can do. So it limits interviews. For example, your first office action, the examiner must say yes to an interview. But if the action is under final rejection, the examiner can reject your interview request. So I put AFCP here because most of the time, if the examiner is nice and flexible, sometimes the examiner will take an interview after final. But other times they won't do it. So then basically the interview would be limited to an AFCP 2.0 request. The types of amendments you can do are limited. You can cancel claims, you can amend claims to make them allowable, but there really isn't much more you can do without an RCE. And usually RCEs are required in response to final office actions, and those are around jugomayan, so which can be quite expensive if you are filing RCEs many times in several cases. As a final note here, the basic strategy here for avoiding final office actions: if you can traverse the rejection, which means if you can argue against the examiner without amending your claims, so you believe the examiner's wrong, you can traverse the rejection. Don't amend your claims then. Do not amend those claims. Argue that the examiner is wrong. And then if the examiner is wrong about a dependent claim, then rewrite that into independent form and traverse the rejection. Rewriting it is not an amendment that should cause a new ground of rejection. So if you rewrite it, you traverse the rejection, the examiner gives you a new ground, rejects the claim again, that action should not be final. The next action. And if you want to add new features, if there's things that you want to put into the existing claims, add new claims for those features. Make new dependent claims if you want to. That will allow you to add the new features without amending your original claims. And if your traversal is successful, if you win on your argument, and the examiner makes a new ground of rejection of the unamended claim, just one, it can just be one claim, the next action should be non-final. Okay, well, and that's it for today. I hope you could learn something. If you missed something or something was confusing, please go back. You can rewatch portions of the video. If you haven't seen my part 1 yet, I suggest you go watch part 1. It's informative as well. And I look forward to seeing you in the next video. ありがとうございました。